Hey, I'm Will from Fed Employees Fight EEO Abuses. I just want to give you a call, reaching out, saying hi to you guys who are fighting your way through the EEO process. Tell you all right off the breakaway, I don't want to sound like sour grapes, but it's a rigged process. I'm going pro se. Pro se has even lower chance of success than with lawyers. Even with lawyers, the loss rate is 98%. Definitely rigged. Point of the process I'm going through right now is I'm about to request a reconsideration. Reconsideration of what? I've had an initial ruling and ruled against me. I appealed. The appeal ruled against me, and basically I'm at the end of my road. My options are at this point: quit, give up, cry. I can do reconsideration, or I can go ahead on into federal circuit court. I plan on going to circuit court. I really, after some point, this complaint that I'm going to tell you about right now is an 18 claim complaint. And it's only one of maybe 4 or 5 total complaints that I have. So I've been suffering from ongoing, nonstop reprisal, hostile work environment, and harassment. And there is some discrimination in there as well. So at this point, in order to request, and it's not a right. I don't get a right. It's not another appeal. I have to be very detailed as to how the judge's decision clearly involved the erroneous interpretation of material fact and or law. So I'm just going to read one example to you. This is the second example that I have. And the thing about it, I study these court cases, study how they lose, right? Obviously do mostly losing. And I study how they win. You study the language. You study what the judges seem to want. I found that, certainly no guarantee. But hey, check this out. Read, it's kind of long. And the reason I took you through that primer is because I found out that a lot of times, even if the complainant, hey, we complainants, we know oftentimes we've been done wrong. We can't articulate how we've been done wrong. We can't map the done wrong to the proper court or law or court citation, and or we can't prop the proper evidence to it. Again, if everybody, I'm a federal employee, so if every federal employee actually filed a complaint and received a fair amount of justice and was compensated for every time they were actually done wrong, we know people cheat the system. But I'm talking about, legitimately discriminated, retaliated, harassed, reprised against. So, the federal system be broke at this point. So there's a lot of chinks in the system. So it's definitely, I found there's different phases to a cut. There's cuts. It's almost like sports. There's cuts to eliminate, less athletes from better athletes. So the laws can be tough. The metrics can be tough to get to, and even those cases when you finally get to them, well, there's a little bit more injustice poured on. So the bar keeps shifting, it keeps moving goalposts. So hey, without no further ado, listen to this. It's kind of long, but I think you might be interested in all the metrics and measures and specificity and details I have to put in it. I found again, the details that you miss out are the details that the judge point out and dunk you. So you didn't prove, you didn't show, you didn't evidence this, so boom, you have no merits. Of course, if you get too many details, they get upset at you and want to throw your case out. Because, hey, you got a backload of thousands, tens of thousands of cases. Don't have all day to read your whole page, one page portion of your complaint. And I got 18 of them. You don't have time for me. So at any rate, I expect the worst. All right. My battle, expect the worst. Why am I still doing it? Been in it for 6 years. Started in 2016, right behind some protected activity. And it's been going on and on since. So item B here, I have the AJ's decision involved a clearly erroneous interpretation of material fact and or 29 CFR 1614.405A. C Universal Camera Corps versus National Labor Relations Board court case blah. And Celotex versus Catrex numbers blah, blah, blah. And Oliver versus Digital Equipment Corps numbers blah, blah, blah. when she ruled on claim number 12 without substantial evidence and genuine facts in the record to support her ruling. It's very important, especially on an initial phase, they're supposed to be able to rule on genuine facts that's in the record. But on appeals phase, they're supposed to do de novo, is what it's called. De novo says, hey, they're looking at it fresh eyes and don't even pay no attention to what the prior judge said. Now, listen, I'll tell you some of the catches that I found in the ruling. Substantial evidence is defined as such relevant evidence as a reasonable mind might accept as adequate to support a conclusion pursuant to 29 CFR 1614.405A. See Universal Grammar Corps versus National Labor Relations Board. In the March 2nd, 2022 appeal decision, the AJ concluded the complainant's computer was disabled because it was infected with malware and that an OIG investigation did not substantiate complainant's allegations. But at no time or at any point in our investigation nor discovery is there evidence or artifacts sustaining the inference that an OIG investigation ever occurred for the computer disconnection matter. And the imaginary OIG investigation had no report number, no date of investigation, no results, no conclusion, no evidence, no statement or affidavit from the investigating officer, nor name of the investigating officials, or anything to verify, corroborate, or support the purported conclusion of did not substantiate complainant's obligations, other than a supervisor who has a vested interest in the outcome and failure of the allegations, bare, unsupported, unverified, and made up testimony. Those are all legal principles. You can't not supposed to just take the word, or unsupported word of any of the complainant or the defendant. And if there's no evidence, there's nothing to support the allegations, then you call that conclusory. You just make up whatever you want to make up. And the judge is not supposed to take that on face value. All right, let me keep going. Conversely, the record is clear that SO1, that's Supervisory Official 1, testifies, I was not aware that his computer was removed from the network. And that's in ROI Exhibit F3, page 752. It's very important that you put those page numbers in sight where they can find that information. If you said it exists or you're getting it out of the record, you want to show it's in the record already. Don't make up any new facts. Don't make up anything that's come late, evidence you got late that's not in that record. Don't bring that up, or they'll slam you hard. SO2, that's Supervisory Official 2, testifies, I pulled the help desk tickets and found that no tickets were open to remove network access from Mr. Farrell. Well, you know my last name wrong, right? ROI, that's an ROI Exhibit F4, affidavit of SO2, page 775. See, I'm being very specific. He said it. I want to point you to it. Don't make them have to guess. Don't make them have to dig through your paperwork to figure it out. Don't have time. They're just going to slam your case. SO2 testifies that his account was not disabled. Oh, that's SO3. Glad I took time to share it talk with you. You helped me find the error. SO3 testifies that his account was not disabled. See the ROI Exhibit F5, affidavit of SO3, page 787. At some point in the RO investigation, SO2 contradicted his prior testimony of whatever it was. Instead, he substituted with, it was infected with malware. You see, he said a minute ago it wasn't disabled. And then he says it was infected with malware. Already we got an issue. And the AJ improperly ruled based solely on the unsubstantiated and self-controverted statement. He already controverted himself. Additionally, the complainant is lawfully entitled to discovery for anything in the record. And in this case, if an OIG investigation existed, then he, the complainant, was improperly or unlawfully denied discovery of the purported OIG investigation. Without evidence to substantiate that OIG investigation occurred and it was the reason for the computer disconnection, then the agency fails to proffer or articulate a legitimate and non-discriminatory reasons for its conduct. You can see United States Postal Service Board of Governors versus Aiken, or Ann Holly versus Department of Veterans Affairs, EEOC request number blah. Therefore, summary judgment should be issued for the complainant on this claim. Why for the complainant? Because we've proven that they failed to articulate a legitimate, non-discriminatory reason for its conduct. It was illegitimate. It's a lie. They contradict themselves. No evidence to prove anything other. All right, so let me keep reading. The AJ's ruling is also improperly fragmenting. The AJ's ruling also improperly fragmented the matters raised in the complainant's complaint in a piecemeal manner. See Meany versus Department of Treasury. EEOC request blah. An agency should not ignore the pattern aspect of a complainant's allegations and define the issues in a piecemeal manner, where an analogous theme unites the matter complained of, ongoing harassment, bullying, intimidation, reprisals, and hostile work environment. Finally, the March 2nd, 2022 appeal commission decision failed to comply with the de novo standard. 2, examine the record without regard to the factual and legal determinations of the previous decision maker, and neglected to review the documents, statements, and testimony of record, including any timely and relevant submissions of the parties, and issue a decision based on the commission's own assessment of the record and its interpretation of law. But instead, the commission improperly upheld the same ruling with no evidence of an OIG investigation. So you see there, now we found that 2 rulings were based on an OIG investigation that never even existed. How in the world could that go down? CCFR 1614.405A stating that a decision on appeal from an agency's final action should be based on the de novo review. See also EEO Employment Opportunity Management Directive for 29 CFR Part 1614 EEO MD 110 at Chapter 9, as revised August 5th, 2015, providing that an administrative judge's determination to issue a decision without a hearing and the decision itself will both be reviewed de novo. So that's another law. Remember the reason why I said that I'm asking for a reconsideration? That the judge failed or improperly ruled on a fact or a law. So there it is. I go on to say, injustice will result if reconsideration is refused. That is, the movement demonstrates that some harm, legal, at least tangible, such as him not being able to prove his claims of discrimination, ongoing campaign of harassment, hostile work environment, and discriminatory retaliation due to fragmentation, would flow from a denial of reconsideration. That's a part of a Cobell ruling, and it quotes FBME Bank court case FBME Bank Ltd versus Mnuchin. See, you have to, and I'm telling you, I've seen people win other components what I stated, but if they don't say that it was injurious to them, I've actually read plenty of cases where they said, well, Mr. Such and Such complainant said such and such, but he doesn't say that there's a problem, it's an injury, so we don't award him anything. You got to be mindful. It's really, really a minefield. I go on to say, even if the appropriate legal standard does not indicate reconsideration is warranted, the court may nevertheless elect to grant a motion for reconsideration if there are other good reasons for doing so. I didn't make that up. that is actually right off the book. The complainant petitions, now, you always got to tell them what you want. The complainant petitions the commission to reverse the ruling for claim number 9. View it most favorable to the non-movement, that was me at the time, and award summary judgment to the complainant for claim number 9 with punitive and compensatory award. All right, took 15 minutes, and that's just one. Mind you, I had 18. I'll share a couple more with you. Let me know what you think about it. Make some comments. Let's have a dialogue. Tell me how your case is going. All right. Bye-bye. And good luck.